Morning.
Unmute. There we go. How are you?
Fine. Good morning to you, Linda.
Good morning.
Are you at the courthouse?
I am. This is my office.
Well, I am not.
You're not? You look like you're in your office at home, right?
That's right. Home office. So
Have you been working? Go ahead.
somebody's waiting for us there. I'll admit them in a moment. Go ahead. What were you going to say?
Oh, I was going to say, are you still playing golf in this cold weather?
Yes. Occasionally. Going to play on Thursday. Going to play on Thursday when it's up in the mid 60s, so it'll be a lot better.
Yeah.
Played a couple of times when it didn't get past 55, and that can be painful with a little wind.
Yes, it can.
Not to mention,
I'm allergic to cold weather. My hands and feet are very sensitive to cold, so I try to stay away from below 50s.
Yeah, we used to have a 50-degree rule. Actually, we still do. We don't ever try to tee off when it's below 50.
Good rule.
Yeah.
Okay, I'm going to mute my mic now if you want to let them in.
Yeah, I'm on my way. Thank you. So, good morning, everybody.
Good morning.
Good morning.
Thank you for all being prompt. We scheduled this hearing today as a scheduling conference to make plans for where we go from here. And I don't have a plan. But there may be some more pretrial or preliminary things that need to be considered before we schedule the big event of a jury trial. And I alluded to that when I sent that last email to all of you, letting you know that I was open to the possibility of reconsidering some rulings that had been made before. And I'm not trying to single out one side over the other. And I'm open to discussing anything with you this morning. So petitioner Ms. Telegina, since you are petitioner, I'll defer to you for the moment. And if you want the other side to go first, that's up to you, but you have the first opportunity.
Thank you, Judge. Good morning to you and good morning to everyone. Actually, I had nothing to say until I got this email from you yesterday night. And I wish you sent this email earlier because I spent a sleepless night, and by the morning, I have a list of at least 5 motions that I believe are important to file and for you to reconsider. The worst case scenario, you denied all of them, but you will get an absolute perfect picture of what has happened before you, what issues I believe are important in this litigation. And I believe that after you ruled on these 5 motions, we will have a plan. Whether we go for trial, whether we not go for trial, whether we go for bifurcated trial as Judge McDonald planned, and what is the scenario of such bifurcated trial, because for the time being, we have no scenarios of bifurcated trial, just a statement that we go for bifurcated trial. So I can send you the list of the motions that I plan to file. I would probably, some of them are almost ready to go. Some of them need some work. So, but probably within 10 working days, I will finalize the sending out of these motions. I will, of course, not be waiting these 10 days. I will be sending them once they are ready, one by one. But that's my estimation of the time that I would need to have these motions ready for your reconsideration. Then most likely my openings will need additional time. So rough estimation, we would need another scheduling conference a month from now, at least. And I would suggest that we both sides come with a plan before this scheduling conference for your consideration.
So let me just ask, the motions that you've alluded to, will these be something new that no one has ruled on before, or are these requests to reconsider motions that have already been ruled on?
Reconsider.
Reconsider, okay. So you alluded to the time it would take you to prepare these. It causes me to question, why wouldn't it be a simple matter of submitting the motion with a request that I reconsider the content of the motion instead of an elaborate rewriting of the motion?
It's not like rewriting, Judge, but I need to review these motions. I need to probably attach additional expert opinion because time has passed and there are a lot of developments since then, so I don't think just simply resubmitting these motions, especially like there was emotions, there was my opponent's response to this, there was a judge ruling that there are some things I agree, there are some things I disagree. So it makes more sense for me to bring to your opinion, to your attention, only things that I strongly disagree and are only matters that I believe should be reconsidered.
All right, then.
I believe it's more efficient for your time and for, yes, that's what I think.
All right, so are you able to commit to deadline by which you would submit these motions?
Yes, Judge. As I said, our worst case scenario, so this is like deadline is 10 days from now, 10 working days from now, but I will be submitting motions once they are ready. I will not be waiting for the deadline. I think two working days per motion. That's, since I'm not an experienced litigator, I'm not a lawyer, I need more time than lawyers to produce a motion. So that's why. And also, I'm working alone, and I don't have paralegal help. Whatever research I make myself. So that's why I utilize more time. It's not that I want to cause any delays in this litigation.
All right, let me address the notion of, quote, working days. I've learned that sometimes creates ambiguities because of the definition of what a working day is. Because one day will be a holiday for some people and not for others. So it's better to use a date specific, which is not subject to any ambiguity. Would you consult your calendar and tell me the date by which you'd be willing to commit to file these motions?
I mentioned working days only because we are approaching the holiday season, Judge. And when I refer to holidays, I mean Texas state holidays, and that's what I believe are holidays. I don't celebrate any other holidays.
Nevertheless, let's use a date specific.
Okay. Well, I would say December 23rd.
Okay, I'll make a note of that without making any final determination here. Did you have anything else you wanted to add before I shift to the other side?
No, Judge, I'm good.
All right. Who will it be, Mr. Wilson or Ms. Peoples?
Yes, Judge. Good morning.
Good morning.
I am in agreement with not rushing to schedule a trial, in the next 30 or 45 days, because I'm concerned about the logistics of doing so, and of course the COVID cases on the rise and the difficulty to impanel a jury and a veneer for voir dire. So I think some time to address additional pre-trial matters does make sense. We recently learned that Ms. Telegina has filed suit in Russia as well, seeking to divide marital property. So in light of that, and in light of the upcoming deadline in this case of December 11th to replead the petition before the court, we are currently evaluating our file and considering which motions that we have filed in the past that we may ask this court to reconsider.
All right, explain to me December 11th.
The December 11th date is the deadline by which Ms. Telegina has been given to refile her seventh amended petition in accordance with the court's granting of the special exceptions. So that has not been filed yet, and depending on what and when a pleading is filed, we will address it accordingly.
Okay, I had originally set December 4th, and on her request, I extended it to December 11th. Thank you.
Yes, sir. Yes, Your Honor.
Okay. All right, so is your side in a position to commit to any kind of deadline at this point? If so, what is it? If not, when?
That's a good question, Judge. I think that the December 23rd suggestion by Ms. Telegina to file motions for reconsideration, I think is a fair one. If for some reason something comes up, say in the Russian case that might require us additional time, I think we could reach out to you, Judge, and request that. But I'm okay with a December 23rd deadline for reconsideration motions.
Judge, if you allow me, I was pointing out to 23rd December deadline with regards to my motions. Mr. Wilson just mentioned that they are considering filing their own motions. Then I would probably need some time to review and file a response. So I would suggest that in case my opponents are filing their own motions for reconsideration, we will approach you via email and request the extension of this deadline, respectively.
Well, I understand. What's going through my mind at the moment is after we see what each side files by December 23rd, we may need to have either a hearing like this or an exchange of emails, as you suggest, to set hearings and maybe establish deadlines for responses. And it's probably not appropriate to make those, well, let me back up. I'm completely open to the idea of setting another scheduling hearing similar to the one we had today, right after the first of the year, setting it today, but to occur right after the first of the year, so that we all have it on our calendars to review what we're confronted with and make plans for how to dispose of them. If either of you have another idea, I'm certainly open to that.
I think that seems like the most sensible plan of action, Judge, just given where we are and with both sides planning what we've discussed today. I think that would be a good idea to come back maybe the 5th of January and evaluate deadlines and probably schedule hearings.
I said after the first year, that week between Christmas and New Year's is usually a non-productive week in American law practice. When I was a sitting trial court judge, we never scheduled any hearings during that week because it was always difficult to get one side or the other present and a variety of reasons. So I'm open to a hearing between, well, the week of December 28th, but it may be impractical for one reason or another, and I'm perfectly happy with using the first full week in January.
Judge.
Open to comments.
Yeah. We may need an oral hearing on one or two of my motions, or maybe all of them, but at least a couple of them. are, and I will be requesting the oral hearing, are, and I will most likely be bringing an expert, and that would be an expert on Russian law. And Russia is having huge New Year holidays until January 8th. So, but they're working on January 31st, and they don't have Christmas holidays. Of course, they're on old Orthodox calendar, church calendar, so they don't celebrate Christmas. Their Christmas is on January 7th. So I would probably, if we are to schedule a date today, I would probably request after January 8th or before January 31st. So it's up to you, or we can delay the scheduling the date, postpone the scheduling the date and see how things goes on and decide later.
Okay, the date you said, the 31st, did you mean December 31st?
Yes. Russia is working until December 31st inclusively. They don't have any Christmas holidays, so I'm fine to have this conference, this hearing on even on December 31st. But I understand it doesn't goes well with everyone else, or after January 8th.
Judge, I'm going to be out of town between Christmas and New Year's. So the week of January 4th, I think would be best. It looks like Miss Peoples has a trial beginning on the 4th. So maybe that Tuesday, the 5th would work best for the parties here.
Well, Ms. Telegina proposes after the 8th of January.
I can confirm any date after January 8th.
Like the 11th, 12th, the week of January the 11th is the first.
Any date. I can confirm any date.
January 12th, will that work for you, Judge?
Have it would, provided that it's in the morning like this.
Ms. Peoples, January 12th looks good on your calendar. Okay.
Ms. Telegina, are you okay with that?
Absolutely, Judge. Thank you.
Another scheduling conference like the one today, and I'll send out the Zoom link, and I'll try to make sure I used AM instead of PM this time.
Plan for 9 a.m. again, Your Honor?
Yes, that's fine. Is that
Okay.
agreeable to everyone?
Absolutely.
Yes, Judge.
So I'm going to give both sides a clouded window on my thinking for you to consider for what it's worth. We have in this case, of course, the premarital agreement and then the marital settlement agreement that modifies the premarital. And in the last motion for partial summary judgment that I just considered and ruled on, I noticed that Ms. Telegina had used the term unconscionability, and it may have surfaced in another motion as well. In any event, I pointed out to you that I didn't think that was ripe for decision, or was even the true subject of the motion for partial summary judgment. But as both sides probably know much better than I do, Chapter 4 of the Family Code has provisions about these premarital agreements and postmarital agreements. In each case, pre- and postmarital agreements, there is a paragraph about enforcement that sets forth the defense of unconscionability. And there are subparts. The issue of unconscionability, the statutes tell us, is a legal decision to be decided by the court as a matter of law. I'm having a little trouble wrapping my hands around how one does that as a matter of law without taking some evidence to peel back the layers of the agreement and find out what all it consists of. But it is clear that it is a court decision and not a decision available for jury disposition. There's a case of Marsh versus Marsh that's mentioned in the version of the annotated family code that I have. And I'm sure there are others that give us a definition of what unconscionability is. For an agreement to be unconscionable, it must be, quote, so far one-sided that no reasonable person could consider it to be an arm's length transaction. And then the statute goes on to require, as for the defense to prevail, that the party defending against the enforcement of the agreement wasn't provided a fair and reasonable disclosure of the property or financial obligations of the other party, did not waive a right to disclosure of the property, and didn't have adequate knowledge of the financial obligations, and so on. So that may be a matter that has to be presented to me at some point in the future, or maybe not. And it may require the taking of some evidence for me to rule on it if it's presented to me, if it's going to be asserted as a defense in this case. So I'll share some other thoughts with you too. Not to suggest for a minute that these are the definitive exclusive issues involved in this case. They're only the ones that have come under my radar so far. It's been pointed out. Well, let me back up a moment. This rule of civil procedure 308B let me get my copy in front of me just a moment. I've got the Supreme Court's miscellaneous docket number 17-9163. dated December the 28th, 2017. Where the court first promulgated Rule 308B, which is attached to their order. And I think that was the version of the rule that was in effect when Judge McDonald had the first 308, well, the only 308B hearing. And I believe the rule may have been amended a time or two since then, but I'm not sure. In any event, I'm going to go on the assumption that this original version of 308B was the one in effect at the time of the hearing, and the one that I'm uncertain whether any subsequent amendment would affect proceedings going forward or not. There's a difference between applicability of substantive law versus procedural law. So, looking at the provisions of 308B, a 308B determination requires the court to consider whether the foreign judgment of a judgment under foreign law violates constitutional rights or public policy. So that suggests a careful look at what constitutes public policy. As Telegina has asserted in some of her pleadings, or pointed out, that the Russian administrative divorce procedure involved in this case had, for example, a 30-day waiting time instead of a 60-day waiting time. Query whether that alone or in combination with some other things causes this administrative divorce to be inconsistent with the public policy of Texas, reflected in the fact that we have a 60-day waiting period. And I certainly express no opinion today on whether it does or is. So have observed that the administrative divorce procedure in this case did not conclude with any acceptance or consideration even of the property division. Unlike the requirement we have in our family law, our family code, that the court approve the property division in its judgment. If the parties have entered into an agreed marital property settlement, then the court has to give its blessing. Essentially. That's in chapter 7 of the Family Code. Seven point oh oh six. So the certificate of divorce document nowhere alludes to the parties' property division or agreement for division of their property. Query whether that constitutes or makes the enforcement of the Russian divorce procedure inconsistent with the public policy of Texas. I express no opinion about that. But it seems to me that we've got some thorny issues in this case that may not have been completely developed yet. And going forward, perhaps they need to be. I express no opinion about that either. All right, there you have it.
Judge, we are off the record, so may I express my just 2 cents? It will not take more than two minutes.
Of course.
In the legal brief that I filed, it's extremely lengthy legal brief, but I suggested to file you the Word version of this legal brief so you would be able to navigate through it easily because it has hyperlinks. So feel free to tell me if you need, and I will send you. But in this legal brief, I actually referred to several cases determining what is public policy. I will not take your time now quoting all these cases, but actually only one. The legislature determines public policy through the statutes it passes, or Texas public policy is reflected in its statutes. So I believe that Texas Family Court is part of the Texas public policy. That is my legal position. And I believe that Russian divorce certificate that states Texas as place of issuance was issued here in Texas in violation of several mandatory clauses of Texas Family Court, and as such violated Texas public policy. And to sum up, I can speak forever, but just to sum up, that would be my first motion for reconsideration. It's almost ready, Judge, to reconsider the Rule 308 order. You may agree with Judge McDonald, you may deny it, but at least you will have chance to look at it from, once again, I will make it more structured, and you will be able to hear from Russian law expert who will testify on Russian law, because Judge McDonald made determination that it is Russian law to apply and enforced this certificate.
Well, by all means, share your legal brief with me in Word format.
I will.
All right, so these matters may have already been considered. I wasn't aware if they had. I saw her finding in the order, but I wasn't aware what issues were laid before her for consideration. All right. Is there, go ahead.
Can I touch on that for a second, Your Honor?
Yes, of course.
The contention that the process that the parties decided to go through to obtain the administrative divorce was part of the hearing that we had on that 308B motion, and included in the findings and order of Judge McDonald from September 12th, 18, there is a finding that the Russian administrative divorce process did not violate public policy of Texas and did not violate Ms. Telegina's constitutional rights. And I think an important aspect of that ruling as well, and there was testimony to this effect, was that both parties, while they were living in Texas, were aware that they could have proceeded through the Texas courts and the Texas system to obtain their divorce, but instead they opted to proceed with the Russian administrative divorce process through the consulate, which as a prerequisite to participate in that process, the parties had to have no minor children, which they have no children, and an agreement with regard to the division of their property. So before they could get that certificate, they had to have met those two prongs.
Judge, I'm sorry, but Mr. Wilson cannot speak of Russian law, and whatever is said now is not very much accurate, to say the least. I agree to everything.
We won't litigate it to a final conclusion at this time. All right. So, is there something else that either side would like to settle this morning, other than what we've already settled with the deadline of December 23rd for filing motions to reconsider, or new motions for that matter, any additional motions? And then the scheduling hearing on January 12th to decide when we're going to hear what.
I'm good, Judge. Thank you for your time.
Okay.
I have nothing further this morning, Your Honor.
Also, well, I'll bring up an additional matter. In some of Ms. Telegina's documents, she has alluded to multiple requests or offers to have settlement discussions. Those are my words, not necessarily hers, but that's the way I interpreted what she said. I seize on that to ask both sides what your opinions are of the possibility of trying to mediate this case sometime in the near future rather than continuing to go down the litigation path. If you're not prepared to talk about that today, but want to bring it up
Judge,
on January 12th, for example, I'd be happy to hear that. But go ahead.
I filed requests for admission of facts with more than 100 requests, and many of these requests were admitted. So there are many facts that are judicially admitted so far. are judicially established as they were admitted by respondent. So what I'm saying now is judicially established. I sent at least 22 requests to put an end to this litigation. All of them were either ignored or denied. During our deposition, respondent's deposition, he was quite clear when he said, and I quote, "There is nothing to settle." So this is legal position of my opponents. We had, I worked hard to schedule the mediation. We finally had this mediation in, I think on November 2018. It was unproductive. My opponents left. And so I open to any settlement offers, but I sent so many of them that were ignored that I feel are like no use, no sense in sending just another one. But again, I would like to point out to everyone that I believe this litigation should have been settled in 2018, and I was open to do so. Because my client, my husband was offered to mediate immediately after this petition for divorce, original petition for divorce was filed. He never attended this mediation. So again, I'm open, I'm happy to settle, I'm happy to discuss settlement, and thank you for offering this once again.
So there was a mediation in November of 2018?
Yes, formal mediation, court-ordered mediation, we had it.
Yes, Judge, we participated in a mediation through the Dispute Resolution Center across the street from the courthouse up there in Conroe. And we were unsuccessful.
Well, this case certainly has some unique characteristics to it, as we all know. All right. I try to observe the rule that doctors go by, and first rule is to do no harm. Somebody wants to raise the question of court-ordered mediation again in the future, and I'll be open to talking about it, if including the position from either side that it would do no good, it would be a fruitless exercise. That would be something for me to consider.
Judge, I'm open to mediation. I'm happy to do it once
again. All right, what else should we talk about today? Anything?
I'm good.
All right. I wish a happy holiday for all of you, including New Year's. I won't see you again. Won't see you again until January the 12th.
Thank you, Judge.
And happy holidays to you as well.
Thank you. Happy holidays to everyone. Thank you.
Thank you, everyone.
Linda, happy holidays to you. Thank you.
You.
With us for almost 3 years.
Yeah. Bye, Linda.
Everyone. Have a wonderful day.